Hello everyone, welcome to the U.S. immigration information. Something significant has shifted in U.S. immigration policy and, honestly, a lot of people are only discovering it at the worst possible moment, at the airport counter, at a consular interview window, or even when logging into a student portal and suddenly realizing something is no longer valid. There are travelers who booked international flights assuming their tourist visas were fine. There are students who registered for spring semester classes believing their status was secure. There are skilled workers who renewed leases and signed employment contracts, confident their paperwork was in order. There are families who planned reunions thinking their visas were valid for years to come. And then, without a personal warning letter ahead of time, they discovered that a decision had already been made. No dramatic press conference naming individuals, no countdown clock, no advance notification in many cases, just a status change inside a government database and immediate real-world consequences. As 2026 begins, the U.S. State Department has confirmed that more than 100,000 visas have been revoked since the current administration returned to office. If you're new to the channel, make sure to hit that subscribe button and turn on notifications so you never miss a crucial immigration information. That number represents one of the largest waves of visa cancellations in modern U.S. immigration history, and it signals something broader than isolated enforcement cases. It signals a systemic shift in how visa eligibility is monitored and enforced. To understand why this matters, we need to clarify what a visa actually is and what it is not. A U.S. visa is a travel document placed in a passport that allows a person to travel to a U.S. port of entry and request admission. It does not guarantee entry. It does not guarantee that a person can remain indefinitely. It does not override immigration law. It simply allows the individual to present themselves for inspection. When a visa is revoked, that permission disappears. Once revoked, the visa holder cannot use it to board a flight to the United States. Airlines are electronically notified through government systems. When a passport is scanned, the revocation appears immediately in border databases. In many cases, the individual learns about the revocation at the airport or through official correspondence after the decision has already taken effect. The State Department has indicated that these revocations span multiple visa categories. They include tourist visas, student visas, and certain employment-based visas. Officials have tied the revocations to a variety of factors, including criminal violations, overstays, national security concerns, fraud findings, and failure to comply with visa conditions. What distinguishes this moment is not the existence of revocation authority. That authority has always existed under U.S. immigration law. What distinguishes this moment is scale and intensity. More than 100,000 visas revoked in less than a year represents a sharp increase compared to prior annual averages. That suggests a coordinated, data-driven enforcement approach rather than random case-by-case action. One of the key mechanisms driving the shift is something known as continuous vetting. Historically, visa eligibility was heavily evaluated at the application stage. Once issued, a visa often remained valid unless a specific incident triggered review. But under expanded monitoring systems, eligibility is now treated as ongoing rather than static. Continuous vetting means that visa holders' records may be reviewed over time. New law enforcement encounters, updated intelligence information, policy changes, or data matches can trigger reassessment. If eligibility is determined to no longer exist, revocation can follow even years after issuance. For affected individuals, the impact can be immediate and disruptive. Students may find their ability to remain enrolled jeopardized. Workers may lose the legal basis for employment. Visitors who traveled abroad may discover they cannot return. Families may face sudden separation. In some documented cases, individuals reported learning of revocation only when attempting to board a flight or after receiving communication instructing them to depart. International students have been among the most visibly affected groups. Thousands of student visas have reportedly been revoked in connection with criminal charges, compliance violations, or security-related concerns. Advocacy groups in several cities have challenged certain revocations, arguing that notice procedures were insufficient or that individuals lacked meaningful opportunity to respond before cancellation. Beyond student visas, the broader visa landscape has changed in additional ways. One development involves expanded use of visa bonds. Applicants from certain countries may now be required to post refundable bonds, in some cases ranging up to $15,000 as a condition of visa issuance. While refundable if visa terms are followed, these bonds increase financial barriers and create additional compliance incentives. This video is for educational purposes only. It does not constitute legal advice. Always consult a licensed immigration attorney for personalized guidance. Another development involves presidential proclamations, suspending visa issuance for nationals of specific countries. Beginning in early 2026, certain countries have faced full or partial suspension of new visa issuance with limited exceptions. These suspensions affect future applicants and operate separately from the revocations already implemented for individuals already in the United States. These proclamations do not automatically cancel valid visas. However, they contribute to a broader enforcement climate that emphasizes reassessment and control. Legally speaking, the executive branch holds broad discretion in visa matters. Courts have historically limited judicial review over consular visa decisions, particularly for applicants outside the United States. That means revocation decisions can be difficult to challenge unless procedural violations or constitutional issues are clearly demonstrated. For current visa holders, this environment underscores the importance of strict compliance, maintaining lawful behavior, adhering to all visa conditions, avoiding unauthorized employment, respecting duration of stay, and keeping contact information updated where required. Even issues that might previously have gone unnoticed can now trigger review under expanded monitoring systems. For new applicants in 2026, expectations should be adjusted. Processing times may be longer, background checks may be deeper, and financial documentation requirements may increase. Social media and digital history screening may be more rigorous. The revocation of more than 100,000 visas is not a standalone event. It appears to be part of a broader enforcement strategy that includes expanded vetting, greater interagency data sharing, increased use of executive authority, tighter compliance monitoring, and higher financial thresholds in certain categories. Regardless of political perspective, the practical reality is clear. Visa access has become more conditional and more actively monitored than in recent years. Anyone whose educational plans, employment arrangements, travel schedule, or family reunification depends on a U.S. visa should stay closely informed through official government sources and, when necessary, qualified immigration counsel. Assumptions are no longer sufficient. Old timelines may no longer apply. Status should not be taken for granted. In an environment of continuous vetting, visa validity is no longer treated as static. It is subject to reassessment. That does not mean every visa holder is at risk, but it does mean that compliance, awareness, and preparation are more important than ever as 2026 unfolds. Understanding how these changes operate and recognizing that visa status can be reevaluated after issuance is essential for anyone navigating the U.S. immigration system today. Staying informed is not optional in this environment, it is protective.